The idea of caring for your neighbor, in fact, the idea of being reasonable, is mostly looked at as a social norm. Or even sometimes you look at it as part of religious doctrines or religious dogmas. The question is, does it really have a place in the legal system? In fact, let's look at this example. Lady Nadia went for child delivery at Bado Hospital. Upon arrival and examination, the doctor recommended that she would undergo an emergency caesarian section. The doctor successfully carried out the operation. 2 days later, she had persistent pain, and after undergoing an X-ray examination in Sasa Hospital, it was discovered that the doctor had forgot a small pair of scissors in her womb. Lady Nadia is aggrieved and intends to sue the doctor. Advisor. Now, with that case, negligence pops to mind. The problem is, you're not going to successfully sue for negligence, okay, unless you can prove the elements of negligence, which is what you're going to look at in this video. Hi, if you're new to this channel, welcome. Make sure you do subscribe, okay, and hit the notification bell to be notified every time we upload a video, okay. We have a lot of segments, okay, from starting and running your business, managing contractual risks, business law, procurement stuff, basically business, finance, and all that stuff. Now let's talk about what this video is all about. The first thing we need to ask ourselves is, obviously, what is negligence? Now, negligence in its simplest form is, well, it's both an act and an omission, meaning it's doing something that a reasonable person will not do, or failing to do something that a reasonable person will actually do. Of course, the question of who's a reasonable person is something else. Negligence stems from the law of tort, and a tort is an act which causes a harm to a determinate person, whether intentional or not being a breach of duty arising out of personal relationships or contract, and which is either contrary to the law or omission of a specific legal duty or violation of an absolute right. Now, you don't want to confuse duties that are arising out of, well, as we pointed out, a contract from those ones that are arising out of the kind of relationship that gives rise to the law of tort, okay? Well, if you're having a problem with contracts, there's a course about contracts, link is in the description. Now, let's move on. You see, understanding negligence, okay, saying that whatever action you did is something that a reasonable person is not supposed to do is one thing. Proving it is another, which means we need to talk about that. We need to talk about the elements of negligence, okay? What makes negligence negligence? What are the elements of negligence? Now, ignoring the doctrine of res ipsa loquitur, which simply means let the facts speak for themselves. If you're going to prove negligence, you have to prove the following three things: duty of care, breach of duty of care, and injury to the plaintiff. So here's how those three work. In fact, let's start with the first one, okay? Duty of care. What is a duty of care? So the first thing you have to know when dealing with negligence is to figure out whether a duty of care exists between the parties involved, okay? Or whether it doesn't. A duty of care imposes that you must take reasonable care to avoid acts or omission which you can reasonably foresee would be likely to injure your neighbor. Now, again, that kind of just gives rise to another question. Who exactly is your neighbor? The question of who your neighbor is one of those questions that I think it's one of those things in the Bible, who's your neighbor and all that. But for legal reasons, okay? The legal answer seems to be persons who are so closely and directly affected by your act that you ought reasonably have them in contemplation as being so affected when you're directing your mind to acts or omissions which are called in question. So when you're trying to figure out whether the duty of care exists or not, there are three things that we ought to look at, okay? So it's kind of a three-part test. So number one, it was reasonably foreseeable that a person in the claimant's position would be injured. Number two, there was sufficient proximity, that is closeness, between the parties. And number three, it's fair, just, and reasonable to impose liability on the defendant. Now, if you go back to the first case, okay, the case of Nadia and the doctor, the question is, did the doctor owe a duty of care? Of course, the answer is, yep, he did, okay, because of all those three things. Now, the second thing breach of duty of care. So when you talk about breaching a duty of care, we're simply saying that you've fallen below the standards of care. What exactly is a standard of care? Standard of care means the standard through which the defendant's conduct is measured. Now, when the matter of duty of care goes to court, courts will always take a look at the following. Okay, the courts will use the following to try to arrive at a conclusion, whether you did fall below the standards of care or not. Number one, the degree of risks involved. Basically, the greater the risk, the more the defendant has to take care. Number two, the cost of precautions. And number three, potential seriousness of injuries. And number four, the importance of the activity. So let's see. You owe somebody a duty of care and you failed to do that, okay? Which means you breached the duty of care. So those two things are not enough for you to be held actionable under negligence. Okay, so duty of care, breach of duty of care is not enough. There has to be a third one. So the third one is injury to the plaintiff. Now, the plaintiff, okay, or the claimant, depending on how you call them in your country. So the plaintiff has to prove that the defendant did cause the injury that they are suffering, okay? So like in the case of Nadia and the doctor, she has to prove that it was the doctor's action that led to the injury that she incurred. I mean, leaving the Caesar in her womb and all that, which is quite unfortunate. But these things do happen in hospitals. I mean, there are always, these cases of negligence, medical malpractice, whatever it is. So, three things. Duty of care. Does the defendant owe you a duty of care? Number two, did the defendant breach the duty of care? And number three, was there injury as a result of the breach of the duty of care? So those are the three things that have to be there if you're going to prove negligence. In fact, those are the elements of negligence. We did talk about the doctrine of, or rather did mention the issue of res ipsa loquitur. So res ipsa loquitur simply means let the facts speak for themselves. So this is one of those scenarios where you don't really have to prove all these three. If the facts are such that, negligence seemed to be just the obvious explanation as to why something happened. No, that is not what happened in the case that we've just talked about. So if you're doing exams, if you're whatever it is, okay, and they give you a scenario, you have to talk about negligence. So start by defining what negligence is, then talk about the elements of negligence and tie them all up together to prove that. If you have any question, do let me know. I'm Moses from Zerite Network, and I'll see you in the next lesson.